The news broke quietly, almost as if it was meant to slip by unnoticed in the stillness of the night. There were no blaring sirens, no dramatic headlines at first, just a subtle ripple that would soon become a tidal wave. But its impact was seismic. Within hours, the story spread from hushed whispers in legal circles to urgent bulletins on every major news network. The nation's capital, already tense, seemed to hold its breath as the implications began to sink in. Overnight, the Supreme Court, in a 6-3 emergency order, fundamentally shifted the balance of power between the courts and the federal government. This wasn't just another legal technicality, it was a dramatic reordering of how the country's most powerful institutions interact. There were no oral arguments, no public deliberation, just a brief, unsigned order that changed the rules for millions. The decision arrived without warning, leaving lawmakers, lawyers, and ordinary Americans scrambling to understand what had just happened. Federal policies frozen for years were suddenly back in force. Programs and regulations that had been tied up in legal battles were now, in an instant, revived, forcing agencies to pivot overnight. Immigration agents, healthcare administrators, and election officials scrambled to respond. Offices that had been operating under one set of rules now faced a completely different reality, with little guidance and even less time to prepare. The ruling didn't just change a law, it changed how citizens and states challenge federal power. Suddenly, the pathways for holding the government accountable were altered, leaving advocacy groups and state officials unsure of their next move. The sense on the ground is confusion and anxiety. Across the country, people tried to make sense of what this meant for their lives, their families, and their futures. A single mother in Texas wonders if her healthcare is gone. She's spent years navigating a complex system, and now, with a single court order, everything feels uncertain again. Her children's well-being hangs in the balance, and she's left with more questions than answers. A young immigrant in California fears deportation. He's built a life, found a job, and made friends, but now the rules have changed overnight. The future he's worked so hard for suddenly feels fragile, as if it could be taken away at any moment. These are the real human stakes behind the legal jargon. For every line in the court's order, there are thousands of lives affected. Families, workers, students, and seniors, all caught in the crosshairs of a legal battle they never chose. The court's decision pulled the emergency brake on a key form of judicial review, sending countless lives into uncertainty. It was as if the nation's legal machinery screeched to a halt, leaving everyone to wonder what would happen next. It came via the court's controversial shadow docket, emergency orders with little transparency. These late-night decisions, often unsigned and unexplained, have become a powerful tool for reshaping American law without the usual checks and balances. No televised arguments, no detailed briefs, just a thunderclap in the night. The public was left in the dark, forced to piece together the consequences from fragments of information and hurried news reports. Many feel blindsided, raising questions about transparency and accountability. How can a decision with such sweeping consequences be made so quietly, with so little explanation? The sense of powerlessness is palpable. How can such profound change happen so quickly and so quietly? The ticking of the clock is a reminder that time is moving forward. But for many, it feels as if the world has stopped while they wait for answers. The aftershocks are just beginning. Legal experts warn that this ruling could set a precedent for even more dramatic changes in the future, as the boundaries between the branches of government are redrawn. America woke up to a new legal reality. As the sun rises over cities and towns across the country, millions are left to grapple with what this means for their rights, their communities, and the very fabric of American democracy. The story is far from over, and its consequences will be felt for years to come. So, what did the Supreme Court actually do? Let's break down this historic decision and what it means for the future of federal law and policy in the United States. In a landmark ruling, the Supreme Court declared that federal district judges can no longer issue nationwide injunctions. Those sweeping court orders that could block a federal policy from taking effect anywhere in the country, no matter where the lawsuit was filed. For decades, a single federal judge, sometimes in a small district court, had the power to halt a federal law or executive action for everyone in the United States. This meant that one judge's decision could instantly freeze a policy nationwide, affecting millions of people, businesses, and even government agencies. That power is now gone. The majority opinion argued that nationwide injunctions create legal confusion and chaos, allowing one judge to override the decisions of other courts and even the will of Congress or the president. They said it undermines the normal process of law, where different courts can weigh in and disagreements can be resolved over time. From now on, federal judges can only issue injunctions that protect the specific plaintiffs who brought the case before them. This means that if someone sues the government, the judge's order will only apply to those individuals or groups, not to the entire country. The case that triggered this dramatic change was DHS v. Laredo Community Advocates. It began as a challenge to a new asylum rule, but quickly became a test of judicial power. The Supreme Court seized the opportunity to address the broader issue of how much authority lower courts should have to block federal actions. By making this decision, the Supreme Court ended a judicial tool that both Republicans and Democrats have used over the years to check the power of the executive branch. No matter which party was in power, nationwide injunctions were a way to quickly stop controversial policies in their tracks. Now, if opponents of a federal policy want to block it everywhere, they'll have to file lawsuits in every single federal district court across the country. A nearly impossible and extremely expensive task. This makes it much harder to achieve a nationwide halt to a federal law or rule. The nationwide injunction, once a potent weapon for advocacy groups and state attorneys general, is no more. The legal landscape has shifted, and the power to stop federal policies now rests with the Supreme Court itself, or with a patchwork of local rulings that may take years to resolve. Imagine if there was a single button that could pause a new law or government rule across the entire country, all at once. That's what a nationwide injunction was. A national pause button, pressed by a federal judge when something big was at stake. When a federal rule or executive order threatened to cause harm, whether to the environment, to civil rights, or to the healthcare system, a single judge had the power to stop it everywhere, not just in one city or state. This action could instantly protect millions of people, buying time for the courts to carefully consider whether the rule was legal or constitutional. This legal shield was about more than just stopping a rule. It was about ensuring that the law was applied equally no matter where you lived. Whether you were in a big city or a small town in the north or the south, your rights were protected in the same way. That's what legal uniformity means, fairness and equality for all Americans coast to coast. Without nationwide injunctions, the country could become a confusing patchwork of different rules. Imagine a world where a rule is blocked in California but still enforced in Florida, or where your rights change just by crossing a state line. That kind of legal chaos makes it hard for people and businesses to know what's allowed and what's not. Both political parties have relied on this tool when it suited them. Republicans used nationwide injunctions to challenge Obama-era regulations, while Democrats turned to them to halt Trump-era policies. It didn't matter who was in power. The nationwide injunction was a way for the courts to step in and say, wait, let's make sure this is right before it affects everyone. This power was a vital check on executive authority. It forced the government to defend its actions in court before those actions could cause widespread, possibly irreversible harm. It was a way to slow things down, to make sure that the rules affecting millions were truly fair and constitutional. The logic behind it was simple and powerful. If a rule is unconstitutional, it's unconstitutional everywhere, not just for a few people or in a few places. Justice, after all, is supposed to be blind to geography. Blocking a policy for just a handful of plaintiffs, those who happened to bring the lawsuit, did little to address problems that affected the whole nation. Nationwide injunctions recognize that some issues are simply too big, too urgent, and too widespread to be solved piecemeal. So, the nationwide injunction became the judiciary's way of saying, this policy is on hold for everyone, everywhere, until we decide if it passes the test of the Constitution. But now, that powerful shield, the ability to press pause for the whole country, is gone, leaving millions without that extra layer of protection while the courts deliberate. The decision shifts massive power to the executive branch. Now, a president can implement sweeping policies, and opponents face a daunting, expensive legal battle in dozens of courts. Only the wealthiest groups can hope to mount a national challenge. Legal chaos looms. A rule could be blocked in one region but enforced in another, undermining the principle of equal federal law. The Supreme Court itself will face a flood of emergency appeals, making it the final arbiter of day-to-day policy. Instead of reducing judicial power, this ruling may make the 9 justices even more central to every major political fight. The system is now more fragmented and more dependent on the Supreme Court than ever. The real-world impact is immediate. In immigration, a harsh new rule could be blocked in one city but enforced just miles away. Healthcare subsidies could vanish for families in states that don't sue, while others remain protected. Voting rights are at risk. A controversial federal directive could purge voters in some states but not others. Environmental protections, workplace safety, LGBTQ+ rights, all could become a lottery of geography. A single federal rule might mean different things in different states, creating confusion and inequality. The consequences touch nearly every aspect of American life. Fundamental protections now depend on where you live. The system is no longer uniform, it's a patchwork. The court split 6-3, revealing a deep divide. The majority called nationwide injunctions a modern anomaly, arguing that judges should only resolve disputes for the parties before them, not set national policy. They say this restores a traditional, limited role for the courts, and keeps politics out of the judiciary. The dissent called the ruling radical, stripping courts of a vital tool to check executive overreach. They warned it will cause chaos, with conflicting rulings and a patchwork of rights. One justice wrote, "Today's decision empowers the executive at the expense of the rule of law. The future of judicial power, and millions of lives, hangs in the balance." The response has been swift and divided. Blue state attorneys general are scrambling, planning multi-state lawsuits to compensate for the loss of nationwide injunctions. Federal agencies are moving quickly to implement policies that had been on hold. Advocacy groups like the ACLU and NAACP are rethinking their entire legal strategy, now forced to fight the same battle in dozens of courts. It's a logistical nightmare, draining resources and forcing tough choices about which communities to prioritize. Meanwhile, red states celebrate, seeing the ruling as a victory for the rule of law and an end to judicial activism. The reaction highlights deep political polarization, not just over policies, but over the very rules of the legal game. The landscape for legal challenges has changed overnight. The most lasting consequence is a patchwork of rights. Federal protections now depend on geography. A rule blocked in one circuit could be enforced in another. For individuals, this means confusion and inequality. A DACA recipient or a patient on federal health care may have rights in one state, but not another. For businesses, it's a compliance nightmare, with conflicting rules across state lines. This uncertainty stifles investment and undermines the promise of equal protection under the law. Critics argue it creates a tiered system of justice, eroding the American ideal of a unified nation. The 14th Amendment's guarantee of equal protection is now in question. The country must confront whether this fractured reality is sustainable. The relationship between citizen and government has fundamentally changed. America faces a new, uncertain legal landscape. This ruling is the latest and most dramatic example of the Supreme Court's reliance on the shadow docket. Emergency orders, issued with little explanation, now decide major issues like abortion, voting rights, and judicial power. Critics say this process lacks transparency and undermines public trust in the court. The decision to end nationwide injunctions came via an emergency order, not the usual deliberative process. This trend injects instability into the legal system. Lawyers can't advise clients, and citizens can't be sure of their rights. Is this a necessary adaptation to a fast-moving world, or a dangerous departure from due process? The answer will define the court's role for decades to come. The rule of law depends on predictability and fairness. America must now decide what kind of justice system it wants.